Hello class, welcome to Agency Law. Trying out some new technology here as far as some screen capture and recording my voice at the same time. This is Professor Dan Crane of Business Law. Welcome everyone, and I hope you enjoy and that this is a useful learning tool for you. So, agency law. We're talking about when a person is acting on the behalf of another person and or entity of some type. This other person, the agent, is acting with some degree of authority or apparent authority to do so. Many types of organized human activity are going to have some type of agency within it. Corporate law actually would be impossible without some sort of agent, because a corporation itself is a legal entity, but it of course requires actual living, breathing people inside of that corporation to be accomplishing something, doing something in order that the corporation is able to fulfill its goals and what it was set up to do. Therefore, a corporation would be unable to defend itself in a legal proceeding or something like that. It would need an agent to defend itself in a legal proceeding, that type of thing. The existence of agents doesn't require a whole new set of laws in regards to tort law or contract law. What you have is the interaction of two different types of law. We'll have this agency law with agents and principals, and we'll see how that interacts inside of tort law, criminal law, those types of things. A tort law that has been breached or broken, a contract that has been breached, will be breached just the same, whether it's an agent that does it, a principal, or just a regular person in regards to that contract. That's our overview. So now we're beginning to get into categories. We're seeing this over and over again in business law. You start off the chapter, it gives you a brief overview, and then it begins to break it down into different segments, different elements. So here we go in regards to agents. There are 5 types of agents. This is how the agent gets their power and what type of powers they have. Here we see an example of a general power of attorney. A general power of attorney would be an example of a broad agent that's going to possess authority across a broad range of transactions in regards to principal. That's just one example. So let's get into some details here. Oh, here's a quick question. We're going to have questions intermittently that we're going to stop at and discuss them for a moment. So here our question that we're thinking about is someone who acts for another and is given authority to do so. If this was on a test, what answer would you select there? In regards to, we got, I wish these were labeled A, B, C, D, but they're not. We've got an agent at the top, a principal, agent or principal, and then a busybody being our 4 choices. The answer is an agent. An agent is someone who acts for another. The principal is going to be the person who's delegated their authority. All right, so we talked about a broad agent for a moment there. Broad agent has very general powers. Special agent is going to have limited powers. You can have a power of attorney that specifies more limited powers. That one we saw was very broad, giving someone a lot of authority. Other times you're going to have less authority. An example of that would be a real estate agent. Many of us are going to end up hiring a real estate agent for a purpose, maybe selling one particular piece of property or helping us buy a piece of property. Maybe it's multiple properties, things like that. But you can see there, that's going to be a limited circumstance. That person's agency will hire an attorney. The attorney is going to help us out with a will. That would be a special agent, because they're helping us out with just one particular limited transaction. Agency coupled with an interest. Agency coupled with an interest is going to be an agent who has an ongoing interest in the property that they were a delegated authority over. So an example of that would be a sports agent who's getting commissions, that type of money based off of a contract on a long-term basis over a particular sports player. Perhaps you would have been delegated authority in regards to some type of song or intellectual property or licensing of some patent or something like that. Then the agent is going to have long-term ongoing agency coupled with an interest in that type of work. Sub-agents. Sub-agents are agents of agents. Don't you love law? We like to make things crazy and complicated with lots of exceptions and nuances, and here's a nuance for you. Sub-agents. Sometimes agents are delegated the authority, or it will be just generally assumed that they would have the authority to have agents themselves that are helping them promulgate the delegated authority from the overarching principle. One of the interesting things here is that when an agent is authorized to have sub-agents to help them, an example of that would be a real estate broker might have other real estate agents under them, or an insurance broker has other agents under them at their office. All of that, all of those contracts they've entered into through that agent, all those delegated authorities are going to be binding upon the principal. So you have the principal, the agent, and the sub-agent. The sub-agent is still binding the principal to those contracts. Hagrid, an agent hired by Hermione, is given the authority to hire their own agents. These agents hired by Hagrid are known as what? And that would be our final answer there, sub-agents. Feel free when I flip to the question, if you want to answer it yourself, I'm going to jump right into the answer. Just go ahead and pause it to give yourself a moment to think. Also, if I'm speaking quickly, which I'm attempting to do because I don't want this video to be too long, just go back and listen to it again, or maybe put me on 1.5 times speed, something like that, whatever works for you. Here we go, into the question. Unless there's an agreement to the contrary, sub-agents are agents for who? These newly hired agents are sub-agents for the principal and the agent who hired them. That's the second option there. Servant. I don't like this term, but it's old school, and that's what it would have been called back in the day. We colloquially call this employee. I like that term much better. The restatement second of agency, you would be familiar with some restatements. We had restatements of contracts previously in the chapter. We had restatements of torts. Again, this is a collection of common law put together for states to potentially adopt and help them out legislatively. So we have here defining a servant as an agent employed by a master, the employer, to perform a service in his affairs whose physical contact and the performance of service is code or subject to right controlled by the master. All right, what's the important part about this? We're talking about an employer-employee relationship typically, but sometimes it will be disguised, and it won't be called employer and employee. It could be called contractor and independent contractor, but those terms don't necessarily define the relationship. The importance is the performed service, the physical conduct of that, is that controlled or subject to the right of control by the master? What we're asking ourselves here is how much control is put on the agent? How much does the principal control the individual actions of the agent? So, if I would be an attorney and I would work for General Motors and I was an in-house attorney sitting at an office inside of General Motors and I only handled matters for General Motors, I would be an employee of General Motors if they're giving me oversight and they're dictating to me my assignments, telling me how long I have to complete them, maybe even giving me some input in regards to how I can complete them, that type of thing. That's going to become to be what would be an employer-employee relationship, even if General Motors would want to term me as an independent contractor. Now, on the other hand, if I'm an attorney and I have my own office and I'm paying for my own equipment, I have my own employees at my office, I pay them a salary, and General Motors is my client, but I have other clients, and I'm getting money from all these different sources, and General Motors, of course, might give me a timetable or some direction or that type of thing, but I'm working for a multitude of clients, and ultimately, I really have control of my calendar, and I can tell General Motors, sorry, I'm not going to do what you want me to do. They might decide to look somewhere else, or they might say that's okay and keep on paying me, but either way, I have control over those things. Then I'm an independent contractor. So according to the restatement of agency, an independent contractor is you contract another to do something, but who is not controlled or the subject of right to control. So you can see here, even in my examples, it starts to get a little blurry in regards to how much control and that type of thing. So it can be tough to determine whether someone is an independent contractor or an employee. And remember, the party's contract does not control. It's the actions, the amount of control by the employer that is important here. Here's some factors: control of work hours, control of how work is performed, control of movement, reimbursement of mileage, withholding taxes of workers' compensation, and who has hired the accountant, meaning if I work for General Motors, do they have an accountant and they determine what my pay is and they take out my workers' comp and they take out my unemployment and my Social Security and all that stuff and I just get a check every 2 weeks? Or do I own my own office and I'm doing all that math and I'm hiring my own accountant? If I'm doing all that kind of work myself, much more likely I'm an independent contractor. But if I'm getting paid as if I'm an employee, much more likely I am an employee. If I'm getting reimbursed by mileage, more likely an employee. They control my movement, where I go, when I'm allowed to go there, more likely an employee, that type of thing. Remember, what about agreements? What if we signed a contract that says I'm employee? What if we signed a contract that says I'm independent contractor? Doesn't matter. Court does not care. What they look at is those above factors and many other ones. Remember, it can be a challenge to determine the difference. And why is this important? We see this question here. Being an employee or independent contractor results in specific legal differences, including, hey, do we need to pay workers' compensation? That's important, right? If I'm a business, I want to know, do I need to be paying workers' compensation for my employee, or is this an independent contractor and I don't have to? Important legal distinction here. Let's see, looking over these answers. An employer must hold, let me see, I think it's the third one. Employer must exercise the may provide more training. Nope. Employer may provide. I believe it's the second answer here. An employer must withhold taxes for an independent contractor. Oh, nope. It's first one. Employer must provide workers' compensation for an employee, but not an independent contractor. It's the first option there. Be the answer to that question. Remember, when I scroll these up, feel free to pause them, try to answer them yourself. Agency is important to businesses because we were just talking about this. You need to figure out how to handle the person, what the tax ramifications, the things you need to be doing in regards to your caretaking and supervision. Also, let's see here. I think the correct answer here, agency is important to businesses because virtually all commercial activity is carried on through agency. That is going to be the most important reason. And that's because we're talking commercial activity, which is corporations, and corporations need agents to function. An agent who has the authority to carry out a broad range of transactions, rather than narrow, would be known as what? And that's going to be a general agent. A general agent, an example could be an attorney, can have authority to alter a principal's relations with third parties. For what kind of purposes? Business only, personal only, for business management only. All those are incorrect. The third one there, either business or personal purposes. Remember, a general, an agent, even you and I, regular people sitting down in our homes, can have agents, right? We can have insurance agents, real estate agents. We're going to hire attorneys. They're going to be our agents. We might hire a landscaper. They're going to be our agent, right? We're the principal. We've hired the landscaper to mow our lawn, but I can't control every little aspect of them mowing their lawn. And if I get too controlling, they can feel free to move on. But we as normal people can be principals and have agents. To determine whether someone, so that is, I got off into that tangent there because you can have agents for business or personal purposes. Important to remember that agency law applies to regular people as much as it applies to General Motors. To determine whether someone is an employee or an independent contractor, we discussed that a lot. The court is going to look to a number of factors to determine that, make that determination. And remember, the contract is not going to control. Now, how do you create the relationship of an agent? And this can be done expressly. A lot of this is going to come, it's going to remind you of contract law right now. We can have express agreements. We can have implied types of agreements by operation of law, like estoppel, if you remember that, or implied contract. It's very similar here, how we can create agency relationships. So we have the more express agency agreement. We have in parentheses there, contract. Remember, contracts don't need to be in writing all the time, right? That's based off of rules of formalities, based off of statute of frauds. So agencies can be created by contract. Potentially, they can be just oral. Some of them are going to need to be written. That's express. Having an express agency, especially one written, is going to be best. Think about it, even if I hire someone to mow my lawn on an ongoing basis, I'm probably going to want to, have some stipulations there that they need to come every 2 weeks. And they need to do certain things like actually mow all my grass. Maybe they, do some weed eating or apply some type of fertilizer, once every 30 days, something like that. You're going to have a number of various stipulations and how that's all going to work when you're going to get billed, all those certain types of things. You really want that in writing is what I'm getting to, because typically when you have a principal and agent, things get complex quickly. All right. Byron enters into an agreement with Kanaka on Melinda's behalf. The agency relationship consists of what? this relationship is going to be between a principal and an agent and a third party, and a principal and a third party. The third party is the person being affected by the principal and agency relationship, because the agent is going to be doing business potentially on behalf of the principal, and so it's going to have up to 3 parties involved, at least in regards to how we're going to structure this for the class. All right, statute of frauds, formalities. When do we need to have our agency agreement in writing? You're going to recognize these from contracts chapter. If the agreed upon agency can't be fulfilled within 1 year, got to have it in writing. In many states, an agreement to pay commission to real estate broker, got to be in writing. In many states, the authority given to an agent to sell real estate, got to be in writing. And that makes sense, right? Because in order to have a contract to sell real estate, it's got to be in writing. We know that from contracts chapter. And in several states, contracts between companies and sales reps, sales representatives, need to be in writing. Also, remember, contracts for sales of goods over $500 or more need to be in writing. Small break here. Hold on a second. Yeah, buddy.
I want to watch a tiny little full guy.
Okay.
Lots of arms.
I'll come help you with that in a little bit. All right, so that was probably your favorite part of this whole thing. You can't deny it. All right. An agency contract must be in writing if it's for more than 1 year for the purpose of selling real estate. True or false? That would be true. A power of attorney delegates the authority of the principal to an agent to act in their place. A power of attorney must be in writing and can be for broad and or special powers. An express agency relationship hurt bad enough. Let's see. How's it going, Emmerich? You okay?
I bumped my thumb.
Bump your thumb. All right, come here.
I just slipped and I just bumped my thumb.
All right, I give you a
My
hug.
knee bumped my thumb.
Your knee bumped your thumb. Oh, man. All right. That is working. At some point, I'll figure out how to edit this, but, we're getting this done here. An express agency relationship can be formed only by a written contract only. That would be false. Implied agency. Similar to implied contracts, sometimes people's actions is going to create an agency. And it won't be an express one by word or by writing. It will instead be by people's actions. All right, so what we have here, this would be by operation of law, similar to estoppel or an implied contract. And this type of agency arises when one person behaves as an agent would, and the principal, knowing that the agent is behaving so, acts like their agent. A good example, we're going to get into some examples here in just a moment. Let's do some agents now.
Oh, what is it?
Hey Leo, I'm working, buddy. Go. Hey.
No,
Go potty. Go potty. I don't know. All right. So this will happen in business. Let's pretend I'm a restaurant owner, and I've got a friend of mine who begins coming in front of my business and begins parking people's cars and acting as if they're a valet. And let's pretend we have no agreement made between us. They just begin to start doing this. Maybe it's a part-time thing for fun to hang out by my restaurant, which I'm sure would be a blast. And so my friend is doing this, and I, as the principal, don't tell anyone that they're my valet, but I might act as if, my actions act as if that's a valet. And one of my actions would be is just letting them be out there and acting as if they're a valet business for weeks on end. That type of acquiescence is going to make people think that that is my valet. And so then if my friend acting as a valet accidentally damages someone's car, scratches it, and then they sue my friend the valet and then also sue me as the quote-unquote principal in that relationship, I would believe that a court would go ahead and use implied agency to treat me as the principal, make me liable, as well as my agent or my implied agent in that type of scenario. So, an attorney can have many different clients with a variety of legal issues. Is the attorney an employee or subcontractor for a specific client? A few of my examples there are going to lead you to likely guess that that would be an independent contractor, and you would be right. Now we have apparent agency. And apparent agency is, not sure if I'm repeating myself, or am I repeating myself? And that's because you might be thinking implied agency, very similar sounding to apparent agency, especially because we're creating it out of an operation of law, sort of an estoppel type of thing. But an apparent agency comes forth from where springs forth from when a principal had an agent, fires the agent, but then the agent continues to do agent-like things and is contracting for you, entering their old principal into some binding agreements, and the principal ends up being liable to those binding agreements. Now the agent's going to end up being liable as well, but that protects that third party who's accustomed to that person being an agent to the principal. People say, well, that might not sound fair. Well, it's what saves the third party who assumes that that agent is that person's principal, and what the principal needs to do in those situations is inform others that that agent has been let go. So if I own a printing company and I need paper, I have an employee, they're my agent, they're the ones who typically buy paper. They buy paper from X paper company, I fire them, but they go ahead and continue to place some orders, and I never informed my associate business that I buy paper from that I fired my employee that typically buys paper for me. Well, I'm going to be bound in that situation. The onus is on me as the principal to inform others that I have let my agent go. Here you might be surprised with that, you might disagree with it, but the thing you can definitely take away from this lesson is that as a business owner, this is something a business owner needs to know as a principal. A minor was injured in a car accident, rushed to a hospital for emergency treatment. Minor's parents were not available to approve the treatment. In most states, the minor's parents are responsible for necessary, such as necessary medical services. Again, that might remind you of our previous chapter in contract law. And yes, the minor's parents are going to be liable. That is true. This is similar to agency law. It's while they're in here, parents being the principal, children being as if they're the agent. You're using an extension of agency law to show the parents are liable for necessaries for their children there. All right, this is the valet example I went through here. You can pause here, read it, and choose the correct answer. Duties between the principal and the agent. Agents are going to have duties to the principal. Principals are going to have duties to their agent. In my point of view, agents typically have more duties than the principal, but let's take a look. The agent owes duties in two categories, one being fiduciary duties. You could think of those as any time you're an agent to a principal, those duties automatically spring forth as a matter of law. You have to have those duties. And then you have a general set of duties imposed by agency law. Those are typically more of, to me, like you're bound by the contract. They're written into the contract as a set of general duties. You might contract around those. The fiduciary ones are kind of the big cornerstones, and the general duties are lesser, but they're both duties on the agent to the employee. These general duties are not unique to agency law. The important note here, right, the fiduciary duties, those are going to be put on your upper level of agents, if you want to think about it that way. You're not your independent contractor or employee type of agents. It's going to be your specific power agents, your broad power agents. Those are the ones that are going to have the fiduciary duty. Those lesser general duties are going to be the ones owed by all types of fiduciaries, also employees. All right, duty to avoid self-dealing. It makes sense that an agent is going to have a degree of information given to them from the principal about the situation, and they might be able to use that information to their advantage. If I hire a real estate broker to help me find a particular rental property in a 5-block radius, they might find a really good piece of property and think, well, I would much rather buy this myself than for my client. That would be wrong. That would be self-dealing. There is a penalty for that. Duty to preserve confidential information, right? Again, agents are going to get this confidential information, and they've got to keep it private. Can't be giving out principal secrets. In addition, an agent might get information through slightly nefarious means. They might sort of overhear a phone conversation, or they might literally go into their principal's office, my boss's office. I'm an employee. I sneak into my boss's office, or maybe I'm in there dropping off a paper and I just happen to flip through some files because I'm curious about something, and I learn of some type of new information, not given to me by my principals, but sort of stolen or acquired maybe in a grayish type of situation. Well, any of that type of information also is going to be private and needs to be preserved confidentially. These duties are not necessarily unique to those upper level special and general agents, but also now we're getting into duties that are going to apply also to employees. Duty of skill and care. need to exercise your skills at standard to that kind of work an employee would perform. In short, cannot do a sloppy job. Duty of good conduct. This is going to matter based upon the type of situation you're in as an employee. Some examples down here. A bank cashier who becomes a gambler could be fired. Makes some sense. A lecturer at an anti-alcohol clinic might be directed to refrain from frequenting bars. Also makes some sense, right? But if I am at a florist shop and my florist might really have some negative viewpoints on drinking, perhaps, well, restricting their floral employees from, going to a bar, once a week and drinking in an appropriate manner, right? Not driving drunk or that type of thing, really is the type of conduct that they can't be dictating in that situation. Duty to keep and render accounts. Agent must keep accurate financial records and make those available to their principal. Duty to act inside your authority and also inside of the realm of perceived authority. If I'm a manager of a business, I might be given, I manage a Panera Bread.
Dad,
Yeah.
come look at this.
Okay. Leo, it's going to be a few minutes. I'll come look at it. Oh my gosh. So I might be given a scope of duty as a Panera Bread manager, but let's say that I've run out of bread dough and we really need some flour, but I'm not specifically authorized to go over to Myers across the street and buy a bunch of flour so we can make some more bread, but I know we need bread for the day. I might go ahead, take the petty cash, run over to Myers, buy us flour so that we can make bagels and bread, even though I'm not specifically authorized to do so. It can be seen as inside of my scope of authority as the manager of the Panera Bread to do so. Duty not to attempt the impossible or the impracticable. This means if you, as the employee, have been attempting your best and beating your head against the wall for a period of time, and you should see the light at the end of the tunnel that what you're attempting to do is not possible, you should at that point stop doing what you're doing. Of course, unless your principal tells you to keep doing it, but you should explain to your principal you don't think it's possible and that you believe that you should stop and not waste your principal's resources, unless, of course, you're specifically directed to do so after you inform them. Duty to obey. You must obey reasonable directions concerning the manner of your performance. This is going to be based upon the industry or trade, prior dealings, those types of things, nature of the agreement, blah, blah, blah. But you need to obey reasonable directions. That is the gist here. For example, counter to the duty to obey a little bit, attorneys have specific knowledge. Doctors would be another one who have specific knowledge about how to do a certain procedure. So if I'm getting lung surgery or something and I hire a doctor to do the lung surgery, me as the patient, I'm kind of the principal, the doctor is my agent, I can only direct that doctor so much, which is probably choosing the schedule and a couple other minor decisions. But other than that, it's basically up to the doctor in regards to how they're going to, operate on me, that type of thing. Shop rights doctrine. The shop rights doctrine is given ownership patents have been expressed from both higher. Right, correct. Shop rights doctrine. This is where you as an employee, your inventions that you create, patents you come up, ideas you come up with, because you're doing those inside the premises of your principal, and it's part of your business. Part of your tasks is to, come up with patents, that type of thing. Those are then going to be owned by your principal, not you as the agent. An agency relationship imposes the duty of care. This is which type of duty? Now remember there, we have fiduciary duties and general duties. One of those is going to be the correct answer. Go back a little bit and take a look and see which one you think the duty of care is. An agent must keep all information regarding the principal's business confidential. This includes information told to the agent by the principal or discovered by the agent by secretly going through confidential files. This is true. Karen ends her job with her current employer, Harper, and sets up A competing business 2 blocks away, Karen may compete with her former employer, but cannot use confidential information learned in the course of her employment with Harper. That is true. An agent must follow directions when performing their job. This is known as the duty of obeying. Sabri has breached her duty of keeping and rendering accounts. Sabri has failed to keep accurate financial records, take receipts, and otherwise act in conformity with standard business practices. That would be true. An agent continues to expend the principal's resources in an unreasonable attempt to gain business when it's clear that such efforts will be fruitless. The agent has breached their duty of not attempting the impossible or impracticable. For some professions, an agent cannot act in such a way as to bring disrepute on their principal's business. This is known as the duty of good conduct. If a principal's directions are ambiguous or allow for discretion, the agent must act reasonably under the circumstances, not straying from the scope of their known power. This is known as the duty of acting only as authorized. If an agent has reason to know of information that's relevant to matters entrusted to the agent by the principal, the agent must tell the principal. This is known as the duty of giving information. So now we're getting on to principal's duties to the agents. Yes, the principals do have some things they need to do for their agent. We have contract duties. As far as our text is concerned, principal's duties are contract duties, not fiduciary duties. I want to take a moment to talk about these items, which are related to agency law. Sex discrimination includes unwelcome advances, an offensive work environment, and or quid pro quo sexual harassment. That's true. Sex discrimination includes all 3 categories of those things, which would be things that the principal would owe the agent. A retail women's clothing store refuses to hire men to supervise the women's changing/dressing rooms. To defend against a claim of sex discrimination, the retail women's clothing store may claim that their refusal to hire men is based solely on the basis of a bona fide occupational qualification. That's the magic words you are looking for. Under Title VII, Essence of the Business, a men's clothing company could require that a position is for males only if the position requires. There's several kind of funny options tucked away in there. The last one, though, a model of men's clothing to show how the clothes would look on men. That is the correct answer. Men and women may be paid different wages under the Equal Pay Act when payment is made pursuant to a seniority system, a merit system, or pursuant to a system which measures earnings by quantity or quality of production. All those things are true. That is how those things can be determined. In considering a claim under the Equal Pay Act, the court considers the disparity in pay for jobs that require equal skill, effort, and responsibility. That would be true. So those are all types of duties, if you want to think about it, that principals owe their agents. All right, back into the text. General contract duties. A principal has a duty to refrain from unreasonably interfering with an agent's work, but the principal is allowed, however, to compete with the agent unless the agreement specifically prohibits it. In addition, the principal has a duty to inform his agent of risks of physical harm or loss that could occur to the agent, right? If I have a UPS driver and maybe they need to go to an area or a particular house where someone else has been attacked by a dog or something like that, and I have reason to believe that the dog is still at that residence, well, I have a duty to my agent to inform them that there could be a dog at that residence that UPS driver needs to deliver to. The principal is obliged to render accounts or monies due to agents, including, and how quickly and how this is determined is based upon different factors, basically whether they're employees or independent contractors. Also, agent's reputation is no less valuable than a principal's, and so an agent is under no obligation to continue working for a principal that sullies their reputation. There's a thing called employment at will. Employment at will is employment where an employee can be fired at any time for any reason, except for, as the textbook says, some bad reasons. An employee can't be fired, for example, for reporting that his employer's paper mill is illegally polluting groundwater, and that's going to be some type of statutory law, statutory regulation that is creating some type of penalties for the principal for wrongfully firing their agent. And additionally, we have a duty to indemnify, which is to reimburse agent for costs. So if I'm a salesperson for my principal and I'm making sales calls and driving around and perhaps taking clients to lunch or that type of thing, they have a duty to indemnify me, reimburse me, unless the agreement states otherwise or how that works. Tort and workers' compensation duties. The employer owes the employee certain statutorily imposed torts and workers' compensation duties. That's going to be by statute. All right, so now we're getting into a principal's liability. Remember, the agent is acting for the principal, so the principal is going to have liability exposure due to the actions of the agent. Here we see a triangle in regards to how this type of liability is flowing. So, how liable the principal is going to be for the agent's actions is going to be based, one of those things is going to be based on the category of authority that the agent has. The strongest form of authority is going to be that express authority. That's when the principal is consenting to the agent's actions. Of course, then the principal is going to bear the risk of any wrongful action of their agent. Now, of course, there's some exclusions, some quid pro quos, but we'll get into that. An example here of express authority, we have an accountant embezzling money from a company by writing checks to themselves. So therefore, they're stealing money from their employer. They were depositing those into their own account. The company sued their bank because the bank did not check these checks, right? So I have some sort of accountant that works for me. I'm a large corporation, General Motors. I've got an accountant that's able to issue some checks. They begin issuing them to themselves, and the company bank or the bank that the company worked with is sort of used to the type of checks that are written out of that account, and then they're sued based on the fact that they didn't realize that this agent was writing checks to themselves. Of course, the company, the principal, was unsuccessful here. They bared the risk themselves for the wrongful action of their agent. Implied authority. The law allows for this operation of law, implied type of agency to occur, and sometimes the agent is going to have authority implied by their types of actions. The textbook here gives an example where if the principal instructs their agent to deposit a check in the bank today, the agent has authority to drive to the bank with the check unless the principal specifically prevents them to do so. It's authority that you would think would be granted along with the task. Some other examples are managers. I use the Panera Bread manager example. Can buy goods and services, hire, supervise, fire employees, sell or junk inventory, take in receipts, pay debts, and in general direct the ordinary operations of the business. The full extent of the manager's authority depends on the circumstances, right? But it's not, their authority is not going to be limited only by those things expressly, those authorities expressly granted to them, but there are going to be some implied authorities that are derived from how parties are acting, how things work in that industry, and just accomplishing that specific task. Depositing a check requires somehow getting that check to the bank. Apparent authority, we talked about that. Previously, apparent authority can rise from actions, and it can arise from previous principal agency relationships that are no longer, were not disclosed to be discontinued, that type of thing. As long as an agent has authorization, either express or implied, they may bind the principal legally. The question on whether or not an agent has apparent authority is whether or not a third party should reasonably believe that the agent, in fact, has the authority granted by a principal, right? It can be, we had the example about the valet parking, but it can also be the employee that was fired, but then we didn't disclose it to the important third parties.
I'm just waiting for my birthday.
You're just waiting for your birthday? All right, buddy. Leave me alone. Dad is working right now. Go. I'm waiting for my birthday too. I don't know about you. Okay. Principals, tort liability. So previously we were kind of talking about kind of a contract type of liability, tort liability, kind of deriving from particular acts. But sometimes tort liability is going to occur really, well, let's just go right into the categories here. We have direct liability. Direct liability can happen.
Dad, there's a bug on the couch.
Get it right now. Tell Leo.
Can you please get...
If a principal directly tells the agent what to do and tells them to commit the tort, the principal is going to have direct tort liability. If the principal themselves commits the tort, right? If I'm a business owner and I go out and commit the tort, well, I'm going to be liable. That should be pretty obvious. And then a principal who is negligent in some means in regards to their directing their agent, they're also going to be liable. Some examples of that would be a principal who fails to supervise employees adequately, gives faulty orders, or hires incompetent or unsuitable people for a particular job. All right, vicarious liability. The idea of the fact that the principal is liable for actions of the agent, and this can extend to even acts with which the principal had no knowledge and even no intention to commit or be involved in. The legal Latin term here is going to be respondeat superior, let the master answer, or the master-servant doctrine, which imposes on the principal vicarious liability, indirect liability, under which the principal is responsible for acts committed by the agent within the scope of their employment. Let's delve into this. Here we have a terrible thing that happened. A bakery is held liable for $2 million in damages after one of its delivery trucks injured a 6-year-old boy. The bakery's insurance policy had a limit of only $1.25 million. The bakery could not absorb the excess and was forced to shut down. Clearly from this example, you can tell vicarious liability is going to be very important to a business. So how can we help avoid this type of theory for a business? And if something happens, how do we attempt to go after the principal? Well, you're going to be asking yourself 3 questions. What type of agents can create tort liability? Is the principal liable for the agent's intentional torts? And was the agent acting within the scope of their employment? You'll consider these questions in turn. Ordinarily, an individual or a company is not vicariously liable for the tortious acts of independent contractors. The plumber who rushes to a client's house to repair a leak and causes a traffic accident does not subject the homeowner to liability, right? That makes sense. So I own a home. I hire someone to landscape my yard. I'm a principal. They're my agent, but they're independent contractors, the category we're looking at. They drive over to my house and they accidentally injure some person or property on the way. I'm not going to be held liable. That's because I hold very little control over the conduct of how, in regards to that landscaper is going to reach my location. In addition, there's a thing called a non-delegable duty or concept, and that is where a person is obligated to provide protection or care for another. So again, from the homeowner perspective, there are some duties I cannot delegate. So if I have a landscaper working on something in my front yard, perhaps I'm getting some new trees planted, and they're going to be large trees, and they've got to dig very large holes in there in my front yard. And the landscaper comes, digs 4 or 5 really large holes in my front yard, and then leaves. I, as the homeowner, I have a duty that I cannot delegate, that I need to go out and inspect and make sure my front yard is going to be relatively safe for it. Well, I shouldn't say relatively. This is a way more complicated matter of law than I'm saying, but as an example for this class's purposes, I should be aware that there's 4 or 5 large holes in my yard, and that my neighbors could, maybe in the darkness or not really looking, or they're not, people are maybe accustomed to walking through your front yard, and they're not going to be looking for a giant hole where they could easily injure themselves. So even though maybe my landscaper really should be the one to put up some caution tape or to finish the job, and I'm not allowed, some dangerous holes to be there, and gone ahead and planted the trees, that type of thing, really I can't delegate that duty. Non-delegable duty. So even though they're an independent contractor, I, as the homeowner, the principal, am going to be suffering some liability. Liability for agents' intentional torts. So this is going to be a tort the agent intended to do. General rule, the principal is not liable for torts that the employee committed intentionally inside of their, even though they are my employee, right? If I have an employee and they're in my office and they decide to just go on a rage rampage, beating up some of my other employees, I, as the principal, am not going to be held liable for those intentional torts unless there would be some negligence there on my part. All right, we have detour versus frolic. This is the important rule here. All right, when your agent is committing an intentional tort or an unintentional tort, they're committing some type of negligence here. For instance, right, some type of car wreck that's injuring someone. The question is going to be 2 types of tests to determine if the principal should be liable for the agent's actions. If I have a delivery person who's going out on a delivery route and they're going from delivery to delivery to delivery on my business, and they injure someone between those deliveries, but they're on my business, well, that's going to be during their employment or during their action. But potentially they take a minor detour. Perhaps they do a little stop off to fill up gas and they didn't really need to, or maybe they do a little stop off because they need to pick up some water or refreshment for themselves, that type of thing. Is that going to be a detour, a little small deviation? In that case, likely the principal is going to be liable for any damages occurring. But if it's what the court would deem or law would call a frolic, which is where I've got a delivery person going from delivery to delivery, they're not doing just a little small detour to maybe pick up a pop for themselves or something like that kind of along their way, and as they're pulling into UDF to get a drink, they actually scrape someone's car, likely I as the principal am going to be liable for that. But if instead I've got a delivery person going from delivery to delivery and they decide to go an hour out of their way, go to the beach and relax for an hour and work on their suntan, likely at that point that is going to be what would be called a frolic, and I, the principal, am not going to be liable for that. Zone of risk test is similar to the detour versus frolic test, detour being detour being liability for the principal, frolic being no liability for the principal. The zone of risk test is kind of a proximity type of thing. So if the delivery guy is going along and makes I'm going to use the word detour again, although probably I shouldn't use that term. They are deviating, they're going slightly out of their path, but they do some type of damage, the delivery guy does. That is likely going to be inside the zone of risk. Principal is going to have liability. Whereas if the delivery guy goes way out of his way, kind of goes outside of his zone of employment or zone of tasks, then the principal is not going to be liable. Those are the two most popular tests. Liability for agent's intentional torts. As a general proposition, a principal will not be liable for an agent's unauthorized criminal acts if the crimes are those requiring specific intent. So now you're thinking about criminal law and crimes that require specific intent, like battery, like assault, like some type of manslaughter, that type of thing. You can, though, have regulatory statutes that are going to create liability for the principal. Example of that would be the EPA is going to have some regulatory statutes that is going to say intent does not matter. If I have an employee that is dumping waste and I, the principal, have no idea that my agent, the employee, is doing that, under an EPA regulatory statute, I'm likely going to be liable, even though I had no idea and did not direct my agent to do that. But that's going to be under a specific regulation. Agent's personal liability for torts and contracts. The agent is always liable for their own torts. So the agent is going to be liable for their own torts. The principal might be liable as well for the torts, right? We're talking about that. Someone is my delivery guy. They make a little stop off at UDF. I didn't authorize it, but they're stopping to get a drink. That's going to be a detour. A principal, I'm going to be liable for the damage they did. But even though I'm going to have to pay out of pocket to that third party, I can then countersue my employee or come up with some agreement with my employee because that is the individual who actually committed the wrong, the tort, the act, the negligence, that type of thing. So I, the principal, can seek indemnity to remedy myself from my agent. The principal is directly liable to a third party if the principal directed the agent to commit the tort. I'm going to let you look through these. I think we were pretty thorough. This is getting quite long, but go ahead, look through this, attempt to choose the correct answer there. A principal is directly liable for harm done to a third party by an employee if the principal, take a look there. We did go through these above. You should be able to select the correct answer. Remember, just pause, because I'm going to slide through these quickly. The principle of respondeat superior, also known as the master-servant doctrine, imposes vicarious liability on. Again, we went on that above, so look through there for the correct answer. Great practice questions here. This is an example of a deviation from employment. The employee takes the company car and goes on a frolic of his own without being on his employer's business. This is an example of a deviation from employment, and that would be true. This is an example of deviation from employment. The employee drives from the main office to a company lunch where he will meet the employer. That would be false. That is not a deviation from employment. Regarding an agent's criminal act, the principal, rather than a person or corporation, read carefully through these. To choose the correct answer there. The second one there, can be liable for the agent's criminal act if the principal directed, approved, or participated in the act, is correct. Regarding the torts of an independent contractor, let's read through these. An employer will never be liable for the torts of an independent contractor. The independent contractor is never liable for their own torts. An employer may be liable of an independent contractor because of some duties of an employer cannot be delegated to another. An employer will always be liable for the torts of an independent contractor. The third one there, the third one. Employers can be liable for torts of an independent contractor if they cannot delegate the duty. If an agent commits a tort in the scope of their employment, the agent is liable to a third party and must also pay the principal for damages incurred due to the tort. That is true. Contract liability. Contract liability is important because you're wondering, as an agent, am I going to be liable for this contract? That's important. If I'm a real estate agent and there's a contract and I'm helping the buyer and the seller get together to sign the contract, what if the buyer or the seller does not go through with it? Am I, the real estate agent, going to be liable for the seller or the buyer not going through with it? Of course, that's going to be very important if you're considering becoming a real estate agent. And the answer is going to be, in general, the agent is not going to be liable, not going to be contractually liable for their principal's contract unless the agent is working for an undisclosed or partially disclosed principal. Then the agent is going to be liable for the contract. What the heck does that mean? That means if I, the agent, don't disclose who I'm working for, then I will be liable for the contract. What's an example there? Example there is perhaps Walt Disney hires me to be their real estate agent to go buy some property, and Disney's concerned that if the seller knows that Disney wants to buy their property, they will crank up their price, or they won't want to negotiate because they know Disney has lots of money and must be very interested in this property to put in the offer. Therefore, Disney does not want to disclose that they are the offeror. Therefore, me, their agent, will be bound to the contract just as Disney will be to that contract with the buyer. Also, if you lack authority as an agent, right, we talked about a parent agency, implied agency, there the agent is going to also have liability. An agent enters into a contract on behalf of a disclosed principal, and the disclosed principal breaches the contract. The agent and the disclosed principal are liable for the breach. That is false. The principal was disclosed. The agent does not have liability. Termination of agency. We are finally to the end. Either by action by the parties or by law, the relationship will eventually terminate. This can be express, implied, or by operation of law. So here, express, right, written or oral. Termination of the agency, right, can be written into the contract how that works. Implied can be the actions of the party dictate that the agency is now no longer in effect. And lastly, by operation of law, the agency can come to a close. All right, thank you everyone very much. I hope that you find this useful. Please send me a message through eLearn if there's something that you would like for me to change. I can't necessarily make certain changes. I do like the format as far as you get to see the screenshots and I'm sort of reading things and speaking to you. I like that rather than you seeing my face. But if you would like to see my face maybe in conjunction with the, I do have quite the pretty face, or maybe I'm perhaps saving all of you from having to look at me for 50 plus minutes. Let me know what you think there. Let me know what you think about the audio quality, the speed, the questions, the format, that types of things. No promises in regards to what I can change quickly, but any feedback is appreciated. Thank you all for your hard efforts in the class. I will talk to you all later. Peace out.